Singapore is shifting AI data responsibility onto brands as deployers, meaning CMOs must audit their vendors or carry it themselves. To unpack what these changes mean for brands is Steve Tan of Raja and Tan, Singapore. So, Steve, what should marketers change first in how they collect and use customer data for generative AI campaigns?
Yeah, hi to you, Sess. This proposed advisory guideline from the Personal Data Protection Commission looks at the use of general data in Gen AI tools and systems, right? So first off the bat, I mean, we need to understand that the context in which it can be used and which we need to consider would be in terms of AI model development, as well as AI systems deployment, right? So marketeers, marketing teams, marketing companies, these days they tend to use AI systems and AI tools to help look at preferences, customer behaviors, and stuff like that, right? So off the bat, Singapore is a consent regime data protection law. So that means that, in terms of trying to gain insights and being able to feed data, right, to train these models, as well as part of the system deployment, right, there would be cases where personal data will be involved. Case in point would be retail transactions, consumer retail transactions, where they look at your past transactions, they look at what you like buying from a particular online supermarket, and then they will throw up, the suggestions to you, as well as, for example, live streaming TV platforms, right? That is another good example. So that means that with this, the focus is underlying data protection law obligations as well as principles will apply, and that one of the key ones would be consent, right? Did we obtain consent from the consumer in question before we can use their data? And of course, we need to look at once such user data has been harnessed and leveraged upon, how are they secured, right, within the system and the whole ecosystem of model developers as well as model deployers, and together in sync together with the brands which could be using them as well.
But in order to make that happen, Steve, do you have any advice on how brands can give clear AI-specific notices without making customer journeys feel too complicated?
Yeah, that's often a bugbear for lots of brands, right? When it comes to engaging with the consumer, it's all about trying to make that journey, the interface journey, as seamless as possible. Um, Unfortunately, in today's data-driven economy, right, where personal data obviously being the lifeblood as well as the goal for individuals, right, in that sense, it can, of course, be, if it gets into the wrong hands, right, it would spell lots of adverse consequences for the individuals in question. So data protection authorities around the world, they look at that with a lot of care and caution. Now, so you've got to balance between trying to streamline the process on one hand, and on the other hand, trying to see how you can comply with the requirements of applicable data protection law. So as far as Singapore is concerned, right, being a consent regime data protection law, right, consent is required. And how do we obtain consent, right? Consent is not good unless the purposes upon which you're going to process personal data, the way in which you're going to use personal data have been notified to the individual, right? So the proposed guidelines from the regulator actually came out to talk about, and they bifurcated between a general notification versus an AI-specific notification. So a general notification would simply be where the document simply notifies the consumer that, hey, we're going to use your personal data for perhaps marketing preferences, that sort of thing, right? Nothing else. Very general. Is that sufficient? The answer is no, right? The Data Protection Authority is seeking to take the position that we need very AI-specific notification where it is brought expressly to the attention of the end user that AI systems will be deployed. Your personal data will be input into the AI system, and they will also need to go to the extent of telling, will such data be used for training the AI model, or simply that such data will be used as part of operationalizing the provision of products or services to the customer in question, right? So, and then that leads to how do we then interface that, right? Oftentimes, consumers, when they sign on with a particular or sign for, or rather purchase a particular transaction, right? Or they sign up to a subscription, there will be onboarding, right? So onboarding is where they agree to customer terms and conditions, so on and so forth. And of course, there's lots of legalese. Do we then couch this AI-specific notification within this large rubric of legalese, or do you need just-in-time notification? So our DPA, Singapore's DPA has, or Data Protection Authority for short, has come out to say that the best practice is to have just-in-time notification. So apart from maybe having it underlying within an external-facing privacy policy or terms and conditions, you could at the same time, when at a point in time when you're going to use AI, right, and feed personal data, right, that is being provided by the end customer into the AI system, come up with a pop-up to notify the customer that this is going to happen, right, and provide the customer with the various pieces of information about AI usage, right, AI harnessing in order to gain insights, right, to the customer so that the customer can make an informed choice of whether to opt out or not, or to withdraw consent subsequently.
Now that we've touched on the processes, where are the biggest accountability risks for marketing teams working with AI vendors and model providers? Would you be able to share this with us?
Yes, certainly. Now, when we talk about risks, right, for the brands, right, when they're harnessing AI systems, right, in order to gain insights into personal data that may be fed into these systems, the very first and primary consideration in terms of risk is the fact that you, the brand, even though you could be using a SaaS product, a SaaS AI product, even though you could be using an off-the-shelf AI system from a third party, right? That responsibility and risk in terms of the need to protect that personal data of your customer does not lie with your that particular model developer, does not lie with that AI system provider. It lies with you, the brand company. Why? Because you, the brand company, you are the one that is directly interfacing with the end customer. You are the one that would be collecting personal information from the end customer, and you would be viewed as the data controller, right? So all the principles and obligations under data protection law, including the need to secure such personal data, would fall on you, the brand owner. Right. The other point, another risk that we need to be aware of, and bearing in mind the first point that I just made is, right, the realities of a brand company, right, or a product or service company that is deploying AI to interface with its customers, right? They typically do not themselves develop or own this AI product or model. What they do is they could be perhaps leveraging on a third-party AI model provider or a third party that is providing an AI product tool, right? And they could very well be continuing as part of that ecosystem, leveraging on that third party to analyze customer data that is fed into the system. So the brand company would be the front-end interface entity, right? The end customer would then feed personal data. That personal data may not necessarily be analyzed internally by the brand product. It could be hived off and outsourced to that model developer company to do so, right? The question then is, for example, right, if there's a cyber attack, right, and the personal data that had been collected by the brand company has been compromised, and that cyber attack could have happened on the third party's network, right, in that sense. Who is responsible? Well, general data protection law would say you, the brand company, being the immediate data controller vis-a-vis the consumer, would be responsible. So the risk then is, how do you ensure from a brand company's perspective that you ring fence the risk to the extent that you can, right, in this ecosystem where you're dealing with a third-party service provider? And the answer to that is be very careful, deploy the correct contracting structure, right? Ensure that there is an appropriately worded contract or contracts, including a structure dealing with your relationship with that third-party service provider that is providing you with that model or that AI system. And of course, you could very well want to pass on as much responsibility to the third-party service provider as well, bearing in mind that regardless that contractually you require the third party to owe you contractual responsibilities, underlying general data protection law will always state that you, the brand company, will always remain responsible for that, for whatever happens to that personal data, right? So you'll be hit by investigation by the Data Protection Authority if there's a cyber attack. But nevertheless, you could very well claw back penalties that you pay to the Data Protection Authority from your third-party service provider if indeed the compromise of that personal data was a result of negligence on the part of that third-party service provider. Of course, there are other risks as well, right? One large rubric would be how do you protect such personal data within this ecosystem? So companies will have to look and delve into that with caution, right? When do you destroy and securely delete such personal data as well as the insights? So these are just a couple of the risks that one needs to consider for the brand company from a data protection compliance perspective.
Thank you so much for sharing your thoughts, Steve. Hope you can join us again soon.
Thank you, Zess.
Once again, that was Steve Tan, Deputy Head of Technology, Media and Telecommunications at Raja & Tan, Singapore. For more news, visit sbr.com.sg.